Hi everyone, in today's video we are going to work through how to write up our exam notes, and specifically today we are going to look at contract formation, offer from offer and acceptance. So this is the first thing that you'll need to show before proving that a valid contract exists. How I've structured my notes is that we've got some key headings, which I'll take you through. We look at cases where relevant. There's no legislation relevant to offer because this is common law. However, if there were relevant legislation, you'd add that in. And what I want you to do is go through the lecture notes that your lecturer has provided, along with your tutorial notes and your reading notes, and add that all in. And it's important that you're as concise as possible. However, you also include enough information so that when you're in the exam or when you're in your test and your brain isn't necessarily working 100% because you're stressed, you have access to everything that you need. So today, like I said, we are just looking at offer from offer and acceptance. And if you like this video, let me know and I will make them for each of the topics in contract formation. So I've started with introduction to contracts. So the first stage of any contractual dispute is to establish if a contract actually exists. So this depends on proper formation. And particularly if you are studying a contracts A course, there will be a lot of questions on contract formation. Now we know there are three key ingredients to formation, and I'm just going to highlight these. So on a side note, if this were a in-person exam, I would print these off, and as part of my revision when I'm going through practice questions, I would be highlighting things. If this is an online exam, then you can format them however you like. However, make sure that everything is really easy to follow. Don't overcomplicate it, keep it really simple, because during the exam, you don't want to be rereading a textbook. So the three things or three key ingredients to formation are agreement. So this is based on mutuality over terms. Agreement exists when a valid acceptance follows a valid offer. And like I said, today's video is just focusing on offer. Consideration needs to be given by both sides and is proof that the bargain exists. And then we have intention to create legal relations. So since a contract is legally enforceable, unlike, for example, a promise or, something that you're just throwing out there. Some other factors that you also need to consider which affect formation include capacity and certainty and completeness. Now, depending on what type of contracts you are studying, so if you're not studying the generic contracts course and perhaps you're studying a construction contracts course, you may also need to refer to privity of contract and the rights of third parties or the form of the contract. And this is why it's important that you are the one that creates your notes. So don't just download them off the internet. Make sure that you are the one that creates your notes based on what your lecturer has been informing you about. So I've got them all here, but for example, if your lecturer hasn't mentioned privity of contract or form and it hasn't been brought up in a tutorial and it hasn't been brought up in a reading, you don't include that. Don't overcomplicate it. Different law courses touch on different things. They all have these main ingredients though. So capacity is also a key ingredient, and so is certainty and completeness. And then there will be other factors which will vary from course to course, depending on what type of contracts you're looking at. Now, when we're looking at a problem question, so obviously in an exam, we'll either have an essay question or a problem question. The problem questions, you need to put yourselves in the shoes of what you would do if you were in court. So in a dispute situation that goes to court, the court will ask, is there a contract? So we are looking for issues of offer, acceptance, consideration, intention, and capacity. We then need to go, well, what were the terms of the contract? Are there express, implied, warranties, representations? What's actually in the contract if there is a valid contract? Then have the parties performed their obligations, or has there been a breach of one or more of the terms? That's often a problem question that comes up, the breach of contract. So what we're doing there is looking for evidence of performance in the facts. Is there a breach? Did the breach cause loss or injury? Remember, loss and injury doesn't necessarily have to be monetary. And what remedies are available to the injured party? So I like to have students start off with this on the front page so that when they are reading through the problem question and taking notes on their scrap paper, these are the things that they're looking for. And the problem question will generally say something like, advise Bobby of his legal rights, or has there been a breach of contract? Advise Susie. It's important to know what sort of things might come up as a problem question from your lecturer. And again, tailor this to your needs. So in our notes for contract formation, this would all obviously be in one document. Today, we're just looking at offer, but offer is part of offer and acceptance. So we're going to put it all under agreement for when we combine our notes together. So a contract usually begins with acceptance of an offer. Therefore, the first thing we need to show for agreement to have occurred is that there was a valid offer. And I want to make a note here. You don't need to include this in your exam notes if you don't want to, but only when you work through the below points, only address them if they're relevant. So I have a lot of notes and a lot of cases included in these notes. However, if, for example, the offer is very clear and very obvious on the facts, make a brief note that, yes, there's been an offer and this is why it's valid. You don't need to go through all of these items because, as we know up here, your lecturer might be including an issue of law that's not just offer. Offer is the first tier of issues. The issue in the problem question or issues could be any of these. So make sure, so for example, when you're going through week 1 offer in your contracts course, the tutorial question is going to have an issue surrounding offer. However, when you get to the exam, the issue may be any of these things. So just make sure that you are aware that we don't go through all of these unless offer is the legal issue that we are discussing. So I always like to start with a definition. Like I said in an exam, your brain can get a bit hazy. Let's bring a definition in. A statement of the terms on which the offeror is prepared to be contractually bound. Also very key that I think helps a lot of students, write down your key parties. So for each type of law, there will be different key parties, your plaintiffs, your defendants. Here we have offeror, offeree. Write it down. The number of students that we see who clearly know what they're talking about, but they've mixed up the offeror and the offeree. You don't want to do that. So make it really clear, draw pictures if you need to, do whatever you need to make sure that you know who the person is who makes the offer and who the person is who receives the offer. And one of the first things I would be doing on your piece of scrap paper is writing offeror and then Susie and offeree, Bentley. You know, you've got to write that down. Character of the offer. So an offer is a statement by one party, the offeror, and again, the person making the offer, to the offeree, which is the person to whom the offer is made. So what we want to identify on the facts, the offeror and the offeree from the facts. The offer must identify terms of an agreement by which he or she is prepared to be bound if they are accepted by the offeree. This is covered in greater depth in contents of the contracts notes. However, it's worth noting that you can't have an offer if there are no terms of an agreement. Now, when we look at whether there has been an offer, an issue which may come up in your problem question, straightforward offers against invitations to treat. If we look at a straightforward offer, an offer is straightforward if made in the form of a question. For example, will you buy my book for the price stated? The offeree then responds positively and accepts or rejects the offer. So yes, I will buy your law book for this stated price, or no, thank you, I'm going on Amazon. Invitation to treat. So this is sometimes used as a tricky point in tutorial questions. Is it an offer? Is it an invitation to treat? Passive conduct, inviting the other party to make an offer. An invitation to treat alone is not an offer, but it is often used as an approach to others that instigates a dealing process. So the invitation to treat, as we will see in the below diagram, may lead to an offer and acceptance. However, it is not the offer itself. So if you've got a long problem question, there may be an invitation to treat before the offer is actually made. I find it useful, and this was taken from one of the references, the textbook. Here we have very clearly up the top a straightforward offer. Offer to sell made by party A, acceptance of A's offer by party B. The contract is formed at this point. Down here, we have an invitation to treat made by party A. Then we have an offer to buy made by party B, and acceptance of B's offer by party A. So in the problem question, the offer doesn't start until here. However, a lot of students get confused and think that the invitation to treat is the offer. And sometimes the facts can be a little bit confusing. So if in doubt, include a diagram and replicate that diagram from your facts on your scrap piece of paper so you can clearly see, hey, what's happening when? What's the timeline here? So then we're going to include in our notes some examples of invitation to treat. We don't need examples of a straightforward offer. One's generally enough to trigger your memory. However, invitations to treat, this is where the problem question might get a little bit tricky. And how I like students to lay out their exam notes, however, again, it's completely up to you on what works for you, is that you have on the left-hand side different types of situations. So we have shop windows, we have self-service shopping, auctions. And this way, in a problem question, if in your problem question you have something in a shop window or something in an auction or someone giving a mere statement of price, you can go, oh, I remember that from my notes. Quickly scroll to this page and see what it says. It's a clear way of laying it out. Now, we also know from our discussions of IRARC, and feel free to watch the IRARC video that I have created if you're unfamiliar, we need the rules when we're applying the law to the issues. So here, against each of these items, I have included the case law, which is relevant for that item. You don't want to be looking through your lecture slides or your textbooks for this case law. You need it easy and accessible. Ideally, each would have the year actually, so make sure that you do that. But this way we know, for example, auctions. The lot displayed is the invitation to treat. The individual bids are offers, and the fall of the auctioneer's hammer is acceptance. So if we go up here, the invitation to treat, that's the lot displayed. That's the invitation to treat. Then we have the people making the individual bids. These are the offers. And then acceptance is when we have the fall of the auctioneer's hammer. So if we had a problem question with an auction, we could go through those facts, say, hey, this is the timeline, and then say this, you know, authority for this statement, British Car Auctions against Wright. It's that simple. That's your rule done. Then we have self-service shopping. So display of goods is the invitation to treat. A customer then selects goods and makes an offer to buy at the checkout, which is then acceptance or not by the shopkeeper. And again, we go through the timeline. What I also encourage students to do, which is helpful, is you'll see here on the right-hand side. So if this is an online exam and you want your notes to stay online, I recommend students do it like this. If, however, you are going to an exam where you're only allowed your hard copy notes, then I would have a separate document with case notes and case summaries and put a little star or highlight the ones that are relevant. So here we have a little case note, and we know that in the case of Boots Cash Chemist, the issue in dispute was whether Boots, a self-service pharmacy, had contravened legislation that provided that certain drugs could be sold to the public only under supervision of a pharmacist. So that's the issue in this case. The crucial issue in Boots Cash Chemist was whether the offer took place at the counter or at some other point. The Court of Appeal decided that the offer was made by the customer at the counter, which was the point of sale. This meant that Boots in fact complied with the relevant legislation. So we only look at these if we need to. But for example, shop windows, the same applies to goods displayed in shop windows. And this case was whether the display of a flick knife was unlawful under the Offence Weapons Act. Well, hang on, my problem question has something very similar with the Offensive Weapons Act and displaying a samurai sword. So what did this case say? Then we can go to our case note and include as much information as possible. Now, how do you know which cases need a case note and which ones are quite happy just to be left as is? That's up to you. However, strong hints that a case is important. Your lecturer spends quite a lot of time talking about it. The case is used in your tutorial as a discussion point. It's in your textbook as an extract of the case, or your lecturer has asked you to read the case. So if your lecturer has asked you to read the entire case, I would do a full case summary using IRARC and have that in a separate document ready to go in case it was an essay question. These little case notes are just useful for if it's a problem question. The next one, for example, that we have is Grainer, and that is noting regarding catalogues that an element of reasonableness must bear down upon the parameters of any offer. The limitations imposed by reasonableness are evident when one considers the case of Granger, where Lord Herschel stated that the transmission of a wine price list did not amount to an offer to supply an unlimited quantity of wine at the listed price. If it did, then the merchant would soon be unable to satisfy a number of binding contracts. Then we've got mere statement of price, tenders, and invitations to council tenants. So this list here will vary depending on what your lecturer has spoken about in your contracts course. Now, some things to look at regarding invitation to treat. So obviously the terminology used by the offeror. Then we have any limitation imposed upon who can accept it. And this is a key case here, which we have the note here. And then any limitation imposed on what is being offered. So I've made some additional notes here on top of that little case note there. So I've got, in making an offer, the offeror may limit the possible acceptors. For example, an advertisement might say that a sale is available to the first 20 customers. The failure to impose a limitation, where a limitation is desired by the offeror and where the offer, excuse the spelling error, where the offer is to the world at large and where reasonable itself does not impose a limitation, as in Granger and Son, may mean that the offeror is bound to a party they did not contemplate. This point is aptly illustrated. So it's good to have these kind of little paragraphs ready to go. So in your problem question, when you're trying to explain, a case or how it's relevant, sometimes it's really nice just to have little snapshots that you can copy, type out in a very similar manner, or copy and paste exactly if it's suitable, so that you can quickly go. It's like prepping for the exam, and putting in that time beforehand pays off in dividends during the exam when you're struggling to put your words together. So here we've got, this point is aptly illustrated in the case of, and I'm going to stuff up how to pronounce this, but we'll call it Lefkowitz. And in this case, a man tried to purchase a woman's mink coat from a clothing store, which had advertised a coat sale. He sued when he was refused service. The plaintiff won because he was not excluded from the class of offerees in the advertisement. And what's important to note here is that while the advertisement did not specify the class of offerees specifically, the store's house rule was that the offer was for women only, and that's why they refused him. So this is a case where the plaintiff belongs to a class of persons not specifically excluded from being an offeree, even though the context suggested that the offeror intended the exclusion. And that's why the terminology is really important. Then we also have to look at any limitation imposed upon what is being offered. And again, we have a lovely little case note here. So you need to select what you put in your case notes or what you put in your comments, or you can put these in a separate document and write really big details on each case. For some of these cases, I would still do a case summary in case they came up as an essay question. For example, just explain the reasoning of Lord Herschel in the case of blah, blah, blah. These little case notes won't be sufficient. However, when you're working through a problem question, these little case notes can really help you explain the application of the rule to your facts. Then we have some other items to consider, which is unilateral offers. And again, this case of Carlyle is one of the key cases for unilateral offers. And I've got a lovely little summary there, which I will leave on the screen for you to pause and read. Then we have statements of price. So a statement of price made during negotiations indicating an offer exists. Again, authority for that, we have Big and Boyd Gibbons, but this would depend upon the context and in particular, the types of things that one would normally expect to be present in a negotiation. And then we have the case of Patterson against Mann. So it's important, again, use your case law. There should be no statements in these items that don't have a case next to them, because otherwise when you go to apply that section of law in your exam, where's the rule? Where's the authority? We get points for the authority. Make sure that you've got them in your notes. If they're not in your notes, they're not going to be in your exam answer. And then we also have competitive tendering. And that means, for example, stating that the contract will be given to the bidder making the highest or lowest bid, in which case only that person can form the contract. And they accept it by making the highest or the lowest bid. And we've got two cases there. What I also think is really valuable for students to do when they're writing up their exam notes is have a little example exam statement. So here I've got when, and then you would put in the name of party A from the facts, and then you would include the action constituting an invitation to treat. So when they did X, Y, and Z, this did not create a binding contract. This was instead an invitation to treat. Party B has not accepted an offer, so their action does not at that point create a binding contract. Done. Or you might say party B has not responded to the invitation to treat with an offer, and therefore party A has not had the ability to accept it, or something like that. And again, we use this. However, I see a lot of students getting a bit stressed in exams. By having this sort of statement ready to go where you just put the parties in, you're saving yourself a lot of stress on the day. And then I've got a note, well, if a case exists which is similar to the facts of your question, there's a high chance your lecturer will use a case that you have studied in a tutorial as the basis for the exam question. You could say something like a similar set of circumstances arose in the case of, and then we insert the shortened citation. In this case, it was held that blah, blah, blah is not an invitation to treat, and then you would explain how that's relevant to the current case. By having these sentence starters with you, if you are getting a bit of a brain block or brain fog during the exam, they just help you get writing and get those words down. So then we have communication of the offer. That's something we need to consider. So a valid offer must be communicated to the offeree. It would be unfair for a person to be bound by an offer of which he or she had no knowledge. Again, case. The offeree must have clear knowledge of the existence of an offer for it to be enforceable. Again, we've got case law. An offer can be made to one individual, but also to the whole world, when the offer can be accepted by any party who had genuine notice of it. And here comes that carbolic smoke ball case again. And if we needed the full facts, it is up here in this case summary. Then we also have the terms of the offer must be certain. So the parties must know in advance what they are contracting over, so any vague words may invalidate the agreement. Then we're going to have an example exam statement communicating the offer. So party A, action constituting communication of the offer on, put the dates here if you've been given them in the facts, via, and then form of communication, so email, letter, etc. Be specific, show that you really understand what the communication of the offer, where that was, particularly in a case where there was an invitation to treat first. So they might have put a poster out, or there might have been an email, and then party B called party A on, 2 weeks later. If you put the dates in, you're showing your lecturer you clearly understand what you're talking about. The offeree had clear knowledge of the existence of the offer. And then here we show the knowledge, so that because they saw the poster or they opened the email, and therefore the offer is enforceable. What's the rule for that? We've got Inland Revenue Commissions against Fry, which is here. And then again, if a case exists which is similar to the facts of your question, well, a similar set of circumstances arose in the case of, insert shortened citation here. In this case, it was held that action constituting communication is not valid communication. Then once we've ticked off the communication, so we've ticked off offer, we've ticked off yes, communication of the offer. Now we're going to look at withdrawal of the offer. So an offeror may withdraw the offer any time before the offeree has accepted it. It would be unfair to expect the offeror to wait indefinitely for an offeree's response. Now that will need to have some case law there. So that's one where I wouldn't be using that in an exam until I had a bracket case authority. An offer made in response to an invitation to treat may also be withdrawn if not yet accepted. And in a problem question, that's what might happen. You might have an invitation to treat, then party B responds with an offer, but then party A doesn't respond to that, so then party B withdraws it. And this is why it's really important to write down your timeline. To be valid, a withdrawal of an offer must be communicated to the offeree. It would also be unfair for a legitimate offeree to lose the chance to enter a contract because the offer was withdrawn without warning. And we have a case here. So I haven't put any case notes in the comments here because otherwise this video would be too long. However, here is where I would be putting little case notes. The withdrawal need not be made personally. It can be made by a reliable third party. For example, one known to both parties, so that the offeree may rely on the withdrawal, and Dickinson against Dodds. A unilateral offer cannot be withdrawn if the offeree is in the act of performing, since acceptance and performance are one and the same thing. And that's Errington against Errington. And if we forget, what's a unilateral offer? Come back here and have a look at Carlisle. Then we would have an example statement. Party A withdrew their offer made on, and then you put the date of the offer, to party B. This withdrawal was communicated to the offeree on this date via this form. This withdrawal was made personally via third party, and then you would discuss Dickinson against Dodds if it was a third party. Like I said, these just help you make sure you're ticking off all those boxes. And then again, we would add in the similar set of circumstances arose in the case of blah, 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 if required. Then we're going to look at the fourth thing we need to consider, which is the termination of offers. So an offer may come to an end because it has been accepted. That's great. In which case a contract is formed. And if that is the case, we would go straight to our acceptance notes. However, other than that, an offer can end in one of three ways. So by passage of time. So because the time set for acceptance has passed, because a reasonable time has passed. And again, with reasonable time, we need that case law. And here, where it says what is reasonable time is thus a question of fact in each case. This would be a great case to have a little case note on with a quote from a judge about what reasonable means. Then we have the second way is by failing to comply with a condition, which is a precedent. So that was financing against Simpson. For example, an offer of employment made subject to production of a satisfactory reference or medical report, or because of death of either party. So if the offeror dies and the offeree knows of this, it is unlikely that he or she would be able to accept and bind the estate of the offeror to a contract. If the offeree, however, accepts an offer in ignorance of the death of the offeror, then a contract may be formed. We've got case law. If the offeree dies, then it is unlikely that the executors or administrators of the estate can accept on his or her behalf. Again, case law. If there's been no termination of the offer, proceed to the acceptance notes. If there has been a termination of the offer, discuss that using case law references. And that there is the basics of your offer. So of course you might tick through all of those and there might be no issues with offer, or particularly if you've been told that offer is going to be something that's discussed in the exam or problem question, it's going to require you to work through those items and really pick it apart. What's also a great idea is to have an exam checklist, and we will build on this as we continue studying contract formation. So for example, if a second video is made on acceptance, you add this in, but it's got things we would look at in our problem question based on the formation of a contract. Handy to have either on a printed piece of paper so that you can physically tick it off, or have it in a document and highlight it as you go. And have we looked at the character of the offer, communication of the offer, any withdrawals, any terminations? Then we need to check at the end of it, well, was there a valid offer? If yes, we would then move on to acceptance. I've got these in grey because we might not discuss them, but if this video was helpful, please let me know and I will create another exam study notes guide for acceptance. If not, make sure that you add in your acceptance points here. Then you would go on to your next items. You know, is there consideration? You know, do they have intention, etc., etc. Also, a really good idea to have things which may be used as discussion or stick points. And these are things that you've noticed come up in tutorial questions, come up in your lecture notes, come up in problem or revision questions. Hope this video has been helpful for you, and I look forward to seeing you next time.